A will is a document that's typically drafted with an attorney, and you express your desires about who will manage your assets after you pass away and how you would like your assets distributed. If you have minor children, you'd also typically appoint guardians in your last will and testament about who you would like to have care for your minor children, or even an adult who has a disability. For a will to be legally binding, it typically requires the testator to express that it's their last will and testament, requires their signature or them to direct someone to sign on their behalf, so they have to have the capacity to make the will. And a will usually has two witnesses. And then some jurisdictions also require a notary, and some, such as California, do not. When choosing an executor or personal representative for your will, it's important to select someone that will be above board and share information and let the beneficiaries know when they know the information is correct or when they're estimating, for example, on the value of an asset. The person not to select as personal representative is one that is going to be reserved and not share information and play hide the ball or kind of power trip on their other beneficiaries. It's much better in our experience if the personal representative or executor is freely sharing information and quickly updating beneficiaries after the death of a loved one so that there isn't time for people to start to get concerned. So the personal representative in a will is frequently a family member, someone you trust, but it isn't always a family member. It can be a close personal friend. It could be a bank, depending on the size of your estate. With your last will and testament, you can make changes to it after you create the first one. It's called a codicil, which is an amendment to the will where you could go in and change who your personal representative is. If you die without a will, it's okay. The legislature has written one for you. It might not be what you'd like. We had a recent probate case that was really sad because the decedent died without a will, and so the laws of intestate succession applied. This particular decedent had two children from a prior relationship that were adults, and they had one child that was a minor and a new spouse. And because they didn't use a will in their planning, the spouse is going to have to find other assets or sell the house in order to keep the minor child in his current surroundings and his same elementary school, which would be nice given that he's just lost his father. A will can be contested in court by anybody that has standing, so typically would be a spouse or a child of the decedent, or it could be a beneficiary that was in a prior version of the will and is not in the current version of the will. And the way to contest a will is typically to hire an attorney and file an objection to the probate, indicating why you believe the will is not properly executed or why the decedent didn't have capacity when they signed it or whatever other grounds of contest that you have in place. If you have any questions about the basics of a will, then contact us at ProvenLaw. We're happy to help.